Okay, good evening, ladies and gentlemen. This is the Carver Zoning Board of Appeals. We are here in Room 1 at the Carver Town Hall. It's July 17th. It's about 7 p.m. And the first thing that we customarily take up during these meetings is an approval of meeting minutes from our last meeting, which was on June 12th, 2024. Has everyone had an opportunity to review those meeting minutes?
Yes.
Yes.
Is there any request for change, amendment, or modification?
No.
No.
Do I hear a motion?
I'll make a motion to approve the minutes as written.
Do I hear a second?
Second.
All in favor?
Aye.
And those meeting minutes are approved. By way of explanation, we are sitting tonight absent our vice chair, who is a little bit under the weather, but fortunately we have a very capable alternate. That's Anita Dahl sitting over to my far right, and she's been with us now for a while, so she has also been with us at previous iterations of this particular case and meetings that we've had on this case. Jennifer Cullum is sitting to my direct right, and over to my far left is James Barrington, and to my immediate left is Mark Poirier. These are well-experienced people with great educational backgrounds and a wide diversity of experience. Mr. Poirier, would you be kind enough to read the public hearing notice into the record?
Yes, this is continued from our previous meeting of June 12th, case 131-2, 2-4, 4-3. Petitioner Margaret Sheehan on behalf of Save the Pine Barrens, Inc., appealing the denial of the building commissioner for enforcement of the Town of Carver zoning bylaws with regard to an industrial use operation without a special permit from the planning board and the unpermitted operation of a construction, sand, and gravel mine, said activities allegedly occurring at property located at 46 Federal Road, Carver, Mass., Assessors Map 131, Lots 2, 2-4, and/or 4-3 in the Industrial Agricultural District pursuant to Massachusetts General Law 40A, Sections 8 and 15, as well as under Sections 2230 and 5223 of the Carver zoning bylaw.
Very good, thank you. Before we go any further, I would be remiss not mentioning that Area 58 is broadcasting us tonight, as usual. This is a live stream, so folks at home can watch. And we also have at least one person in the audience recording as well. Now, I noticed, due to the interest in this case, that we have an overflow crowd, but we do have some empty chairs in the hearing room, and we have some empty chairs on the side that could be set up. So if this handsome gentleman over there on the right, whose back is against the wall, could perhaps lay out a couple of chairs and get some people in here, I'd be grateful. It'll take a minute for him to do that. And ladies and gentlemen, please come in. Ms. Sheehan, no. Take that sign down. Take the sign down. This is an impartial hearing. Take the sign down. Or you can take it and remove yourself. Your option. Your option. Don't argue with me. Take it down. This is an impartial hearing. Thank you. You can have it outside. You can do whatever you want with it, but not in here. Okay. Thank you for that. And again, people, there's some chairs here in the hearing room and also outside. Now, as you folks can observe, Chief Mark Dufely is with us tonight. Good evening.
Good evening.
And the board, through the chair, has asked for some data that the police might be able to provide concerning traffic concerns that were spoken to by many people at our last hearing. And so I would turn the floor over to Chief Dufley to give us some indication as to the data received from his traffic control sign out there.
Certainly. Thank you for having me tonight. At your request, I monitored our traffic out on Federal Road and reviewed data in our in-house records management system. We placed a traffic sign, radar sign, out on Federal Road a few weeks back, and it's been monitoring data ever since. It sits there 24 hours a day. It monitors the speed and provides a traffic count. It gives a report every day of the previous 7 days, so each report adds a new day to that report. I brought the last 3 days that I have, and that shows that the average speed on those 3 days was 34.1 miles per hour, 34.2 miles per hour on one of the reports. It shows a number of vehicles traveling by that sign at 4,777, 4,781, 4,806, which is pretty typical for that area. By comparison, I have a speed sign out on Cranberry Road as well, and that traffic count is 7,400 cars pass by in a 24-hour in a 7-day period. So it's not unusual amount of numbers. The speed limit at that road is 35 miles per hour, and the average is coming at 34.1. There are some outliers that have gone faster. What the sign doesn't tell me is what type of vehicle they are. It's just monitoring the vehicles coming by radar and tracking the data for us. So that was the data that you asked me to provide for you, and that's the capabilities of the sign that we have. We do have officers throughout the 40 square miles of town that monitor speed with cruisers and respond to numerous complaints about speeding vehicles, which is a problem here in Carver and every town that has roads. For the past 3 years, there have been on Federal Road where there were 3 accidents, motor vehicle accidents in the immediate year past, from July 1 of last year till this July 1. And there were 5 in the year prior to that and 5 in the year prior to that. Those accidents appeared to be, from what I can read in the accident reports, caused by either inattention, speed, or avoiding animals in the roadway.
I ask members of the board now for any questions they might like to direct to Chief Dufley concerning his testimony. Mr. Barrington.
So the number of accidents, that was on Federal Road?
Yes.
Okay. And 3,
Yes.
and then 5 and 5?
Yes.
Okay. Any serious injuries? Was there?
I only looked at the 3 from this current year, and no, there were not serious injuries.
Okay.
I didn't look at the reports from the ones, the 5 before and 5 before that. So.
Okay. Thank you.
You're welcome.
Mr. Poirier, do you have anything?
Nothing from me.
Nothing from me.
Ms. Dahl?
No.
Okay. Based on the data that has been received by the police department, do you anticipate taking any proactive measures to alleviate speed or traffic concerns, or do you see that this is a fairly normal traffic flow with fairly normal speeds, given the fact that there's always an outlier or 2 or 3?
So I wouldn't take any additional steps. I would continue our officers to on regular patrol to patrol that road as they patrol all. The data that I have doesn't show that there's a need to be down there for a prolonged period of time other than routine patrol, which we do on all roads.
And the location of the sign was in a place such that it was close to and could observe traffic going in and out and in the area of Reed Custom Soils?
Yes, there's not really many numbers over there. It's hard to describe. It's in the northbound traffic lane, so coming in from Wareham into Carver, and it's in the area where the entrance to Ocean Spray is, in a straightaway area, which is where we normally put those.
And the data that was obtained from these signs was for a 7-day period, consecutive days,
That's correct.
beginning on what day and ending on what day, Chief?
So we've had it out there. I don't have all the reports in front of me. We've had it out there for a couple of weeks. The reports that I brought with me, the first one that I have is the dates 7/9 to 7/15, and then the next day would be I'm sorry, 7/8 to 7/14, and then 7/7 to 7/13. So moving in a 7-day period.
Very good.
I have a question.
Go ahead.
Chief, I'm just wondering, could you give us, for comparison, is there another area in town where you've had to be more aggressive in your enforcement activity, let's say, as opposed to are there other areas of town where you have greater concerns? Or?
So we receive on a regular basis calls from citizens to alert us to problems in areas, and we deploy either officers there or these signs there to determine what's going on and to determine what time of day we should be placing officers there. And that varies in the time of year. Cranberry Road right now is one because the forest is open, it's summertime. A lot of people travel that road, but it changes with the year. You know, it changes with the time of year and the type of situation that's going on. We have several roads up north. High Street is one that we get neighbor complaints all the time about speeding vehicles. There's a lot of curves on that road as well. So
Sure. Okay, thank you.
you're welcome.
Anything from anybody else?
No, thank you.
Chief, thanks for your input. We're
You're
grateful.
welcome. Do you need me anymore? Am I all set? You need me anymore?
I know you've been working all day long, and now you're here with us tonight, so please go home.
Thank you very much. Have a good night. If you need anything else, please let me know. Thank you all. Have a good
Thank
night.
you.
Okay. Late this afternoon, the chair received detailed memos, legal memos, from counsel for Makepeace. Where is he?
Good evening.
I'm unhappy that these communications were received from our counsel for the first time this afternoon. Are you aware of that?
I am aware as of today that they had not been sent to you before today. Yes. I did not know that before today.
And we have a board policy of long standing, because this had been happening consistently over the years. We have a board policy now of at least a couple of years, where we don't accept these things if they come in less than 48 hours before a hearing date. Most of us up here are still working full-time jobs, and it takes lay people especially, who don't speak the same legal language that you and I do, time to read and reread and understand these things.
Yes.
And consider them.
Yes.
So I'm going to give you a choice this evening. Your choice. And it is this. If you feel as if you want this board to consider the written memos that have been sent, one in the form of a letter and another one in the form of a long email, then we will consider them, but not tonight. You will have to come back another day so that we can give these memos proper consideration. That's your first choice. Your second choice is to speak to these memos verbally. Now, the folks up here have not seen these memos. They came to me, as I said, very late this afternoon. So what would you prefer, Mr.
I
Cross?
prefer I'd prefer to comment on that if I could just for a moment, but then give you an answer if that's all right. I can do it in the reverse order if you'd prefer. I'm more than happy to speak to them verbally before you this evening, but at the same time, because I don't want you folks in all candor to think that I am not mindful of the fact that many of you still work and that you have a 48-hour policy. When we received Ms. Sheehan's memo, I think at the end of last week, I realized, okay, I guess we need to respond to that. And what I thought best, what I was provided with email addresses was your counsel's email address and your personal email address. I thought it intrusive to send email to your personal email address on this matter, and I made that decision not to do that. And we sent them to Ms. Quessel, who I have great respect for. Apparently, they were lost in her spam. And that's why they weren't received in advance of the 48 hours. That having been said, I'm mindful of the fact that you folks haven't seen them. I don't, please don't take this the wrong way, I don't really want to come back. So I'd rather address them. I just wanted you folks to know this wasn't me at the last minute thinking, I think I'll send these folks these memoranda. We did send them on Monday morning. They just didn't get to you. But I'm more than happy to accept that and to comment.
All right. So long as you understand that we will not be reviewing, or these folks will not be reviewing, the submissions that first came to our attention this afternoon.
That's fine.
You will be speaking to them, and that's fine, but we're not going to be reviewing those written submissions that came in today. Is that agreeable with you?
That is fine.
Yes.
Correct.
Mr. Crossan, you have the floor. What would you like to tell us about these memos and the points that you made therein?
Just so I can understand, to be clear, that's all you want me to address at this moment. There'll be opportunity to address other things that you've asked us to do at other points during the evening. Is that correct?
Yes, one thing at a time.
Okay, thank you. Let me address the last one that I sent off to you today, if I may. It had been bugging me, if you will, for a while that I was sure that I had seen this claim before. And I kept thinking, man, I have seen this before, but I could not find a record of it. There wasn't a record of it in my hard copy files, and I couldn't find it in my email. But I ultimately did. Unfortunately, at about, I'm thinking 1 o'clock this afternoon, it was a verbatim application for your review. Rather, let me back that up. It was a letter sent to the building inspector in April of 2023 from Ms. Sheehan, making not only the exact claims that have been made in this instance, but verbatim the exact claims, word for word. Now, I have subsequently heard in an email from Ms. Sheehan a response saying, well, the building inspector never responded to that. I don't know the answer to that question. I will say this as well, and you may tell me I'm wrong about my substantive conclusion on this, so forgive me if I am. In her application for public hearing to you folks on this occasion, she stated that under General Laws, Chapter 40A, the building commissioner's response to her letter on this occasion in 2024 was due on March 7, 2024. That the building commissioner did not issue a response to that demand, but rather it was simply, it went unanswered. And then she said, and this appeal is made within 30 days of March 7, the date the building commissioner's response was due, based on the presumption, I presume, I can't imagine why else it would have been said, but that she concluded that there was a deemed date at which the appeal period started and ended. And so I'll accept that. I would suggest that one might think that would apply equally to the 2023 letter. And if she were to argue that no, because he didn't respond or give us a reasoned decision then, the appeal period didn't start then one must question whether this appeal is appropriate at all, if that is the case.
Which appeal? This appeal?
Sure, if it is true.
So you're arguing timeliness.
What I'm really doing right now, Mr. Chairman, is telling you what I sent to you today and making a point with respect to it. I really want to get away from it, to be truthful, but I think it is a valid consideration, but there is a timeliness issue there. That having been said, I very much believe that one of the reasons I'm comfortable going forward on the basis of conversations we've all had in the past and your analysis and town council's analysis of this issue, is that irrespective of how one views that 2023 letter, this matter should not move forward, and that the law supports that conclusion. So I'd like to address that, if I may.
Go ahead.
Is that fair? Thank you. And I have to admit that I too have to look at my notes on this because I wasn't prepared to do this, but I understand your request. It has been argued by Ms. Sheehan that this is somehow a different claim arising currently from an aggrieved party. I think that the law, including the law issued or in decisions written by the Supreme Judicial Court of the Commonwealth of Massachusetts, make it clear that Save the Pine Barrens is not a person aggrieved in this instance, and therefore lacks standing to bring this matter.
How so?
How so?
Yeah. How is it not a person aggrieved?
In order to be a person aggrieved, one has to show with particularity that they are somehow distinguishable from the community at large. That is not the case here. The argument has been, principally, by the way, that the truck activity has increased traffic on Federal Road. That is not a harm. If it is a harm at all, it is not one unique to Save the Pine Barrens. It simply isn't. And if one looks at the decisions that have been issued by the SJC, by the Appeals Court, and by the Superior Court, it is pretty clear that Save the Pine Barrens is simply not a party with standing in this instance. They are not distinguishable from the community at large. And it is not adequate for an association to rely on their stated purposes to establish that harm. And I think that there is ample case law, and I'm candidly believing, and I can provide that to you, by the way, right now if you want me to read off the citations, I'm happy to do that. I think you probably already have them, to be perfectly candid. I'm going to guess that you folks have seen them, and that Ms. Quessel has seen them and understands them. But I'll do as you see fit. More than happy to provide the citations if that would be helpful to you all.
Continue.
Thank you. Moving off the standing issue, I would also make the point that the appeal is simply untimely. By the way, I would take the view that because, even looking at her argument in a way that is most favorable to her, it is an appeal of the special permit that was issued 10 years ago. There is no circumstance in which anything has occurred that has created a right separate and apart from that special permit that would give her an appellate right at the moment.
And for the record, when we
Yes.
speak of a special permit in this
Excuse me,
instance,
I'm sorry.
we're talking about a special permit that was issued by,
Excuse me, by the, actually, it was issued by the planning board
yes, it was.
of this town. That's
Go
a
ahead.
separate issue, by the way, but it was issued by the planning board in Carver in 2014, 10 years ago. Even if one were to somehow accept the argument that it is not the special permit that triggers her rights, there were the other events that we've all participated in, including the 2021 proceeding before you folks, when this matter should have been brought up. So it is untimely, and that sort of leads us to the claims preclusion piece of this matter. That claim should have been brought, and the law is clear. That claim should have been brought, candidly, back in 2014, but certainly it should have been brought at the time of the others, even giving her the benefit of the doubt. That is, if you'd like, I'm more than happy to go into the elements of claim preclusion, but to be candid, I think you know those, and I'm trying not to spend more of your time on this than I should. And by the way, when I say if you'd like me to go into them, I understand I'm asking your advice as to what I should do, and I'm not trying to do that. I'm trying to be respectful of your time.
Are you finished?
I am finished.
Thank you.
Thank you.
Now, you had something else you wanted to talk to us about?
You had asked us when we were here last time, to make at least a good faith effort to have conversations with the persons who spoke at the last hearing, Ms. Sheehan included, and all of the others. And presumably, maybe to make an effort to speak to other persons who candidly might be more representative of the general sense of things down by Cranberry Village. We have made that effort. We have made that effort. And what I'd like to do, if you don't mind, is I'd like to just go through the sequence of events, both with respect to my email exchanges with Ms. Sheehan.
Confidential.
No, those email
Hold on,
addresses
hold on a minute. We're not doing this. Don't interrupt the gentleman. Do not. You're going to have plenty of time. You had plenty of time in the last hearing. You're going to have plenty of time tonight. Let him finish his remarks.
If I may.
Excuse me
I'm
for
sorry.
interrupting you.
Excuse me, Mr.
Go
Chairman.
ahead, Mr.
If I may,
Mr. Cross.
and I'll just address that for a moment. I had urged that our meeting that is the meeting between Ms. Sheehan and I, be treated as a confidential settlement discussion because I believed it might actually help us to get to something positive. That is what she's referring to. It has nothing to do with the email exchange, trying to set up a meeting, and it certainly has nothing to do with the rest of the sequence of events that took place since the date of the last hearing in follow-up to your request.
Proceed then.
Thank you very much, sir. On Tuesday, June 18th, I apologize if I come out of sequence here. I just typed these out to myself when I was coming here, just before I came. I wrote to Ms. Sheehan reminding her that you had asked us to meet, and then I asked that she provide a few dates and times that would work for her and her group so that I could try to coordinate schedules with my group, if you will, the Makepeace folks and me. On Friday, June 21, Ms. Sheehan responded to my request for a few dates and times by stating that she had conferred with her clients and others and that they would meet with us on Friday, June 28th at 3:30 at the Carver Village Clubhouse, the resident association's clubhouse, I guess.
That was June 28th, Mr. Cross?
That was on June 21st, her response.
But the meeting was scheduled for the 28th.
She said it was to be scheduled for Friday, June 28 at 3:30. That was sent to me on Friday afternoon, June 21st. I unfortunately didn't see it until that weekend. I don't really recall why. Maybe I was at work, maybe I was with my kids. I just don't remember. At about 12 o'clock p.m., so just 12:15, I guess, Monday, June 24, 2024, I wrote back to Ms. Sheehan explaining that I couldn't meet then because I was out of town on business and I was flying back on Friday. And as anyone here probably knows, when you're flying north-south along the East Coast in July, you can schedule your flight for any time you want. It'll go when they want. And it usually has nothing to do with the time of your scheduled flight. So I simply couldn't meet with her on Friday, and I apologized for that and said I could not do it. I again asked for a few dates and times that would work for them, again, hoping to try to coordinate to have a real group of our folks there. I also suggested that a meeting at Town Hall, rather than in a hall at a clubhouse, would be more conducive to a productive conversation, because candidly, I thought that Ms. Sheehan intended to turn this into another social media event, and I wanted to try to get somewhere.
Let's just go on with the recitation
I
of the
just thought I ought to
dates.
explain why I suggested Town Hall.
Let's just go on. Go ahead.
But on Monday, June 28 at 2:45 p.m., just about 2.5 hours after that email I wrote to Ms. Sheehan, I received a call from Mike McVeigh telling me that a member of the Cranberry Village Residents Association Board of Directors had called Makepeace looking to speak to me about a notice that was published at Cranberry Village, telling everybody that there would be a meeting in the association clubhouse to address the concerns of the Residents Association members regarding so-called sand mining occurring next to their property. And it said the meeting will be at 3:30 on Friday, June 28. Without ever having found out whether I was available for it, they posted it in any event. The notice also stated that Meg Sheehan would be representing the Residents Association at the meeting. Wednesday, June 24, excuse me, I'm sorry. Let me see if I can find it. Also on Monday, June 24th, Mike McVeigh, had mentioned to me that the member of the board of directors made it clear to him that they were baffled by this, that Ms. Sheehan did not represent the Residents Association. She did not represent the board of directors. They did not want the Cranberry Village Residents Association dragged into Ms. Sheehan's issue. And she explained that to Mike. But I knew that she was looking for me, or I was told that afterward. On Wednesday, June 24, 2024, I returned the call to Ms. Bose, a member of the board of directors, to explain that I had already told Ms. Sheehan that I had a prior commitment on that day and would not be available. Ms. Bose explained to me that Ms. Sheehan does not represent the association or the board, but rather a rather small group of residents who happen to share Ms. Sheehan's views. She also made it clear that the board felt that the association had a very good relationship with Makepeace and did not want to get dragged into the dispute. Further, also on Wednesday the 24th, Ms. Sheehan wrote to me suggesting a meeting on Friday, July 5th. I explained that my sons were flying home for the holiday. I don't see them enough, and I was spending the day with my family, which I'm guessing a lot of people did. I could not do that. We still had almost 2 weeks.
Excuse me. Hold your thought.
Yes, sir.
This is the third time I've had to interrupt this gentleman's testimony. Now, if you cannot keep your comments in the front row to yourself, I'm going to ask you to remove yourselves.
I'm sorry.
All right, don't apologize. Just listen to what I'm saying. I don't want to hear this right
I
now.
don't like that.
Okay, if you don't like it and you're having difficulty staying silent, you can step outside. I don't want this gentleman interrupted again, just like I wouldn't interrupt you or Ms. Sheehan or anybody else who wants to speak. And for those of you who attended the last meeting, I took every single hand that was raised in this room. Without interruption, everybody was allowed to testify. So please, be respectful. Let's get through this tonight. Mr. Crossan, continue.
Thank you. And by the way, I'll just note, if you'd like, if it would help to demonstrate the veracity of my comments, I'm more than happy to provide the email between both of us.
Continue.
Let's see, where am I? On Thursday, June 27, Ms. Sheehan wrote to me criticizing Mike McVeigh for writing to some of the folks who had spoken at the last ZBA hearing to offer them an opportunity to meet with the company and to address their issues. She referred to Mr. McVeigh's email as an unnecessary tactic. She also reiterated her request that we hold an open forum at the Village Association Clubhouse, having taken the view that Town Hall was not a neutral site because people here had rolled against her on issues. Tuesday, July 2nd, 2024, at the request of the Cranberry Village Residents Association Board of Directors in its entirety, we met with the board to discuss this issue and to offer to work with them on any issues they may have with the work being done.
What date was that, please?
That was on July 2, 2024, sir.
Continue.
They reiterated it was a good meeting. They asked several questions. They reiterated that they felt that they had a very good relationship with Makepeace. that they felt that they have been able to work with Makepeace, that they believe they can work with Makepeace, and that they did not want to be dragged into this issue. Wednesday, July 3, 2024, I responded, bear with me for a moment, to Ms. Sheehan, noting that Mike McVeigh wrote to those offering comments because you had asked that we do so. I then asked Ms. Sheehan to identify her clients so that I could make sure we did not communicate with any of them directly against her wishes. Finally, on Tuesday, July 16, 2024, Ms. Sheehan and I met for about an hour and a half in Kingston.
Where was the location of that meeting?
It was, Ms. Sheehan picked it. It was originally supposed to be at a place called Cravings. Turned out Cravings was closed. And we went to a little coffee shop called the Blueberry Muffin in Kingston on Summer Street.
What was that date?
That was just yesterday.
July 16th.
And the meeting was with the Board of,
No, this last meeting, I'm
no,
sorry.
the one before that
Oh,
was with the
excuse me.
Board of Directors of the Cranberry Association?
That's right.
Cranberry Village Association?
That's right. The entire board.
That was July 2, right?
That was July
Second.
2.
Yep.
Thank you.
Without getting into the substance of any of those discussions,
Yes, sir.
I don't want to hear them.
I
I
understand.
don't want to know anything about the particulars of those discussions. However, I am going to ask you, Mr. Crossan, if you have any reason to think that the parties are moving together and might be able to resolve their differences.
I'll answer it this way, if I may. I always take the view that when people are sitting at a table, you have hope of accomplishing something until people push away from the table. And I made that comment at the meeting yesterday. And I genuinely and generally believe that. At the end of the conversation, I gave Ms. Sheehan my cell phone number. She gave me a phone number. I said, perhaps there'll be a point where we can have a conversation. But no, I did not believe that it was going to lead anywhere.
Do you have any reason to believe that if given more time and the opportunity for a second meeting with follow-up or follow-on discussions, that that opinion of yours could change based on what you heard yesterday?
I like to settle things. I prefer to settle things. I did not leave that meeting believing that I could get anywhere.
Do you have anything further to say to the board at this time?
Not at this, if I may, I just want to make the point that in the conversation, that Mike McVeigh would like to tell you what the company has done to try to address some of the issues that have been raised and some of the things that we have discussed with the board. If you'd like that to be done now, it might fit sequentially well with it.
Mr. McVeigh in the hearing room? There he is. All right, come up. I agree, this is sequential, so you have an opportunity now to speak to items that you think might address, at least in part, some of the concerns that were raised by the petitioner and town residents at the last hearing. I don't want any discussion about the discussions between Ms. Sheehan and Mr. Crossan.
Right, thanks.
Those are out of bounds, okay? Just tell us what you folks are preparing to do or are prepared to do.
Sure, so first off, thanks for having us tonight. Relative to, in no particular order, we'll start with dust and sand. That was I heard that. That was a concern that was raised both last meeting and with the board. So for dust, we've sort of deployed the Makepeace water truck sort of on an on-needed basis to what we call 46 Federal Road and 59 Federal Road, so just the sites to the east and west on Federal Road, the relevant area. Sand, so we went ahead and commissioned a professional street sweeping company to come in 4-hour blocks every single Saturday. They've come in, I think now 6 times. I've got the logs here with us. They professionally sweep the streets from the corner of Cranberry and Federal all the way, let's say, almost to the beginning of the landfill. They spend 4 hours doing it, including the entrances to 59 and 46. What else? Speeding. So we conveyed the concerns that we heard at the May 29th meeting to the police department, and I think you already heard from the chief of police tonight relative to the enforcement that was taken and I guess, the result of that. And, talk about the water. That's been an issue on that road for a time. We had a plan in action prior to anything like this, and we just went ahead and executed it. So we had a meeting on site with Carver DPU director, I think John Woods, told him exactly what we were going to do. We did it in-house. We went in, we cut back some trees. And just for everyone's reference, anytime there's been a significant rainfall event, Federal Road on the west side, there's almost a pretty wide collection of water that makes people swerve into the other lane. It's an unsafe situation. It's been that way for a long time. So we went ahead with John Wood's blessing, cut down some trees pursuant to going in and basically building a swale. It turns out that the work we've accomplished so far has, to date, fixed the issue. Now, so as far as I know, the issue is relatively solved. We're going to be looking at different options about how to proceed, but that issue, I believe, is resolved. And then lastly, we'll say communication, right? So, Mr. Chair, I remember you saying, please, we want you folks to be good neighbors. So first thing I did was I wrote 4 letters to certain speakers from the last meeting in all sincerity. Didn't get a response, and that's fine. And all I was going to do is talk about the same issues we're talking about right now. And then 20 days later, on June 24th, I sent a certified letter just following up. If you want to meet, I gave him I think I gave him my desk phone. I might have gave him my cell phone. Reach out, email, anything you want. We'll meet you wherever. I did not hear back. Like Mr. Crossan said, we had a really productive meeting with the entire board of the Cranberry Village Residents Association at our property. Very productive. We're going to have subsequent meetings. Some of the concerns that I'm talking about right now are brought up. And then lastly, I think I'd be remiss if I didn't mention that for a long time, for most of my entire time at the company, that area is a cell phone dead area. And Mr. Chair, you may recall that Industrial Tower and Wireless came in front of this board a few years ago, wanted to put a monopole up. They did so with the support of the fire chief. We made a commitment to the fire chief, Chief Weston, that we would donate the money necessary to install and to buy and install an emergency repeater. Happy to report that emergency repeater, I believe, is fully operational, although the cell phone towers has no carrier. That came at a very significant financial cost to us. I have the bill here, and frankly, I'm proud of that. And essentially, that covers it.
What is an emergency repeater?
Yeah, so I knew somebody would ask that. So I went ahead and looked it up. I think what it is that in a low cell phone service, it sort of enhances the emergency.
Boosts the signal, so to
Boosts the
speak?
signal, yeah.
Okay.
And I don't want to speak out of turn, but the chief reported that he's very happy.
Okay.
So,
Where's that cell phone tower located?
it's actually on one of the parcels that Mrs. Sheehan misidentified as having anything to do with this issue, but I think it's on, so it's a triangular 50-acre lot just north of the Ocean Spray Receiving Station. It is, yeah, 131 4.3.
Okay.
Assessors map 131, lot 4.
It is, Mr. Chair, it's the only use of that property. It's otherwise completely forested.
So let me go through this again, make sure that my notes are correct.
Sure.
You say that you're using Makepeace water trucks now more frequently to control dust. Is that true?
That's true.
How often do you send them out there?
Well, since the last meeting, we've sent them out twice.
How often would you normally send them out had you not received all of these complaints?
I can't speak to that.
And how often do you expect to send them out going forward?
As needed. So there's several gentlemen on site who can make the call to, essentially the manager of the driver, and it hasn't occurred yet. It hasn't been necessary.
Now, these street sweepers, they do it for 4 hours at a shot, right?
Correct.
How many times have they been out there so far?
I've been out there 6 times.
And how often do you intend to send them out going forward?
For the foreseeable future.
You said every Saturday. Is that what you
Yeah,
said?
they've done, I've got the
Okay.
log here,
Yep.
and they've done, it looks like they did 4 Saturdays in a row, and then they did a Wednesday, probably before the holiday on the 3rd, and then they just did the last Saturday.
Thank you.
And you cut some trees down, you kind of made a swale, and that water now is draining away from the road? Is that,
Well, we cut the trees down, haven't initiated the work to make the swale, because the problem has, pardon the pun, evaporated, but we are now gonna look at less intrusive, maybe just plantings that'll just maintain.
how is cutting down the trees removing the water issue for you?
That's a good question. It was just enough, it was just an adequate amount of trees so that the machinery could get in. It's right off the roadway. I'm sorry, I'm not a hydrologist or an engineer.
I'm trying to understand, by cutting down trees at John Wood's
Yep.
permission or recommendation, how does that alleviate the condition out there?
I'm not a hydrologist either, but I will note that the intention was to create a swale that would draw the water in, and it has succeeded. Now, the intention candidly was to do more work to create a swale. The question really at this point, and I think they'll have this discussion with Mr. Woods, is that necessary? Is that important? Because the truth of it is the water is no longer a problem there.
Why is it no longer a problem? I'm trying to
It's not
understand how
puddling.
taking of trees alleviates the water problem.
I don't know that I'm not a hydrologist either. The puddling is no longer occurring there.
I've heard it. I've heard, now that you say it, I did ask that question, and I remember saying something. Maybe the agitation of the soil has sort of opened it up in a way that the water can travel, as opposed to slide off the surface of the ground.
Mr. McVeigh, do you have anything further?
I do not.
Mr. Crossan?
Mr. Chairman, I would just note, if I may, that there are 2 officers from the Cranberry Village Residents Association Board of Directors here this evening, who I believe would like to comment this evening. I don't know whether you want that to be done now or in the public comment period, but they are here, and I think they can speak to this issue.
Public comment period.
Thank you, sir.
Attorney McVeigh?
I'm good, thank you.
Attorney Crossan?
We're both good.
You may withdraw.
Thank you all.
Ms. Sheehan?
Well, I have 2 things. I would like to read a letter from a Carver resident who was unable to sit through that recitation of Mr. Crossan's emails.
Is this lengthy?
Yes, it is, but it's important.
It looks like it's multiple pages.
It is.
Can you summarize this?
I don't think so.
Would you prefer then, or would you like to submit it to the board for its review?
It's already been submitted. It was turned in hand on July 11th.
And who is the author?
The author is Mary C. Dormer of 162 Plymouth Street.
Okay, so if you could hold your thought for a moment. I believe that the board has been sent that letter and has reviewed it. I
That's
see Mr.
correct.
Poirier nodding in the affirmative.
Yep.
I hear Ms. Cullum saying yes. I see Ms. Dahl shaking her head in the affirmative, and Mr. Barrington. Yes, everybody has seen that letter.
That's correct.
Everybody's read that letter.
Yes.
I remember sending it off to everybody, so I don't think it's necessary to read it into the record tonight.
Oh, well,
It
I
is
do-
part of the record.
This is a public hearing, and the public has the right to hear what is in the record. Have you
They have the
posted it
file.
on the
They
have you
have
posted it
access
on
to
the website?
file. We're not going to sit here and listen to you reading a letter, a multiple-page letter that this board has already seen and reviewed. This letter will be available in our file, and is available for viewing whenever anybody wants. But in view of the fact that we are somewhat time constrained, it's already pushing 8 o'clock, we want to give you the opportunity to respond to Mr. Crossan and Mr. McVeigh and make whatever other points you would like to.
Well, my points will only take a few minutes, so let me read a few highlights anyway from the
Yeah,
letter.
if you can summarize, that would be great.
I'll just read it verbatim. Can
No,
anyone
no,
ex-
no, 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 no. We're not reading verbatim.
Well, okay.
I've made my
so-
ruling clear on this, and I want to take a poll of the board members at this time. Mr. Barrington, do you feel as if you need to hear this letter read to you verbatim?
No.
Mr. Poirier?
No.
Ms. Dahl?
No.
Ms. Cullum?
I've read it.
We've
Well, then
all-
I'll summarize it.
Summarizing would be fine.
So, can anyone explain why Makepeace has been allowed to operate a commercial sand and gravel business when Carver's bylaws prohibit it? The employees of Makepeace and their job security cannot and should be a consideration for the board. If Makepeace is concerned about their employees' job security, they can refrain from engaging in illegal activities. There's illegal sand mining in order to extract sand from the aquifer, clear-cutting rare pine barrens. There's a reference to tax evasion, which is the willful attempt to circumvent the tax law in order to reduce one's tax liability. This relates to the fact that Makepeace keeps its land in agricultural tax classification while conducting a decades-long commercial sand and gravel mining operation. There's a reference to corruption and the solicitation of a private favor by official action. This relates to the many gifts, including the one referred to earlier tonight, that Makepeace makes to the town of Carver in order to make the chief happy, quote unquote. So it's this writer's belief that these donations to the police department, such as the ATVs and the walking tracks, relate to a bias on the part of the town. And in fact, I will add that this chair has himself stated that Makepeace does such great things for the town. So this also references the illegal operations that the majority of Makepeace's sand mining abuts environmental justice communities, that the inactions of the town of Carver to protect the resources around these environmental justice communities is shameful, exposing populations to untold amounts of contamination and preventing them from having a safe and healthy community to live in. She also addresses the chair's treatment of me at the last meeting, appalled at the disrespect that I was subjected to at this and other meetings when I tried to speak. She describes your treatment of me as contemptible and a palpable contempt, staring at the ceiling, swiveling in your chair, and rolling your eyes while I was speaking. She praises me for stepping up to represent the voices of the people who are ignored in the town of Carver when they come before this and other boards to make their concerns known. So she also references to your request that Makepeace sit down with the residents. Again, I'm going to object strenuously to Mr. Crossan's representation of this. I provided dates, both of which he was he stated he was unavailable to meet. I guess he was flying on a plane. Didn't provide any other alternate date, and a meeting with the Residents Association of the Cranberry Village is not a substitute for a meeting with a community. So once again, she requests that the board issue a cease and desist order for the illegal operations of Reed and requests that Makepeace be barred in perpetuity from ever operating a mining operation in the town of Carver again due to the threats to the community and the water supply.
This is a letter authored by a Mary
C. Dormer,
Dormer, dated
July 10th, 2024.
Is that true?
Yes, it is.
Go ahead.
I have now summarized the letter. I would like to address the points that Mr. Crossan has made and to follow up and make a final argument to this board. As she indicates, we certainly don't feel like we will get a fair hearing tonight, but we will nonetheless make a request that the board act in an objective manner. As to Mr.
You may proceed.
Crossan.
But we take umbrage at your remark that you don't believe you're getting a fair hearing or a fair opportunity to speak. Now, having said that, And without devolving into personalities or name-calling, let's get to business.
Okay, so I would just like to follow up on what Mr. McVeigh was saying. I don't believe that the town of Carver owns Federal Road. I believe that's a county road, so I don't think they have any right to go out there and cut any trees. And certainly their homemade erosion control measures, or whatever they were alleged to be, they admit they're not hydrologists, so why are they making swales? But that's beside the point, because all of that has nothing to do with whether or not they have a special permit. They admit they do not have a special permit to operate a trucking and freight terminal. What they have is a temporary permit issued by the planning board in 2014 for a manufacturing facility that does not exist. We have done a public records request to find out what the activity is that was allowed under that planning board special permit. As we showed in our PowerPoint presentation, which we sent to you and asked you 4 times to be able to show, which you apparently are not going to allow us to show, but that outlines and shows, we've given you copies of the permit. It is not for a trucking terminal. It was for a temporary manufacturing facility alleged to be for an agricultural use. The information that we have provided to you from Reed's own website shows that this is a commercial construction, sand and gravel, processing and distribution facility. Mr. Kane, who's the president and CEO himself, talks about the 160 independent trucking companies that Makepeace uses to haul sand in and out of its Reed Custom Soils facility. You yourself have no evidence whatsoever of the number of trucks that come in and out of the Makepeace facility. Whether the police chief is putting counters at some unknown location, we have no evidence of that. There were some verbal representations that were vague. They don't talk about the number of trucks coming in and out of Reed. Just because there are cars on Cranberry Road coming and going, and they might be at a certain speed, he didn't give us any truck trips. Our evidence that we have presented to you shows that Makepeace itself has represented to the state of Massachusetts, when it represented this Reed facility as an agricultural operation, told the state there were going to be something like 230 truckloads of sand and this agricultural material coming out of Reed. So times 2, that's about 50. And we've given you truck counts and videos and other things that citizens have done in order to try to figure out how many trucks are coming in and out of that trucking and freight terminal. So they never built the manufacturing facility. They never built any aspect of that project. They never put in the stormwater system that they claimed they were going to put in. We gave you that evidence in 2024 in May in our letter. We then came here on May 29th, and you heard from residents of your very own town about the impacts they suffer from the excessive truck traffic on the road. It's completely irrelevant, as I said, whether the police chief has counted vehicles on Federal Road and Cranberry Road. You have stated that you believe Makepeace is a great company. The 2021 excuses that were concocted in order to reject our claim then are very reminiscent of what's happening here. I assume you're going to go down the road of, we don't have jurisdiction because it's collateral estoppel, it's res judicata, you don't have standing. We have standing. Makepeace is wrong. Those 2 legal arguments are wrong. We did not waive our rights when we failed to pursue the lack of action by the building inspector in May of 2023. The violations are ongoing. They're continuing to operate. Nobody waived any rights when they didn't pursue that. So if the illegal operation is going on, the public has the right to seek enforcement. So you can throw up all of those defenses and excuses, but this community is shining the light on Makepeace's operations and what's going on here in the town of Carver and across the region, frankly. We will not stop fighting for the people's rights whose are supposed to be protected under your own zoning bylaw. That means keeping this community safe from excessive truck traffic, making sure that people have safe streets, clean water, the peaceful use and enjoyment of their homes, and that they are free from trespass by Makepeace, acting with the blessing and the cover of the many town boards, including the Zoning Board of Appeals, who protects Makepeace from having to comply with the law. So that's all I have to say tonight. Issue is not going away. We are not going away. I strenuously object again to Mr. Crossan's mischaracterization and reciting of emails that I sent with a subject letter of confidential negotiations. He maybe now suddenly is referring to the actual substance of any discussion that we might have had. That was a material misrepresentation. I sent those emails in good faith. He comes in here and recites verbatim what I wrote in an email. That is not someone acting in good faith and in trying to reach a negotiated resolution. That's someone who's taking something that a trusting person sent in a confidential email and twisting and turning it around, just like Makepeace does time and time again. They can come here and talk about police counts, but it has nothing to do with whether or not they have a special permit. They have not showed us a special permit. They don't have one. They are operating illegally, and it's your job to stop it. Thank you.
Okay, stay there. Ms. Sheehan, could you stay there for a minute? I do have one comment that I want to make and then a couple of questions. This board does not concoct excuses or make stuff up. I find that choice of word from you a concocted decision based on concocted legal theories, which you say are without basis. Offensive. Not that you think that they're without basis, but that we're concocting things to protect Makepeace. So I want that said for the record and for everybody who's listening tonight. This board arguably is the most independent board in the town of Carver. We do not answer to any other board. We only answer in the event that there's an appeal, and a successful one, where the judge says you did wrong. I might add, and I think you know this already, Ms. Sheehan, that this board, and I've been on for a long time, and these other people have been on for years now as well, has not been reversed in 30 years. As you're finding out when you file your appeals. Now, I have a couple of questions for you. Can you estimate for me how long you believe Makepeace has been operating in the manner you describe in your application? That is to say, with a sand and gravel mine operation that involves trucking activities. How long do you think that's been going on?
We've already answered that, Mr. Chair. I'm not
I'm asking
falling for
again.
any of your traps, okay? I was treated in a disrespectful
Look,
manner.
are you going to answer the question?
No, I am not.
All right, then we're not going to listen to personality attacks. I've already
Okay.
told you that. If you're going to lose it on
Well,
me,
I have been insulted
to
and
you.
demeaned in front of this board
you are
time
going
and
to-
again.
You're doing a disservice to your clients by reacting this way. I had a simple question. How long do you think they've been operating?
I
like
have
this out
already
there?
answered that question.
All right.
I don't believe I need to answer it again. I've provided you with documentation
Okay.
that shows how long they've been operating an illegal truck
Would you
and
say
freight
it's
terminal.
been more than 10 years?
I already answered that question.
You said that 3 times, and I'm asking you a final time. Do you wish to answer that question, or do you refuse?
I would like you to answer that question, and maybe the building inspector could go out and
I'm asking
investigate.
the question because I want to hear it from you.
I am not answering that question. I have
Okay.
already answered it.
All right, I'm going to mark down that you refuse to answer that question when asked. Now, What I'd like to do is take some comments from the public. And I know Mr. Crossan mentioned that there are a couple of members of the Board of Directors of the Cranberry Residents Association. Are they still here? Yes. They are? Would you like to make a comment tonight? And you can bring up the second person, too, for support if you'd like.
There you go. I don't need that. I'm loud enough.
So, could you identify yourselves for the
Yes.
record?
Brenda Bacall, I am president of Cranberry Village Residents Association.
And you are?
I'm Mary Bowes, and I'm the secretary on the board.
And were you present at the meeting that Mr. Crossan referred to in his remarks?
Yes, we were.
Okay. So why don't you share with the board whatever you would like to share about that meeting and how you think it went and whether your concerns were heard?
So the way the meeting came about, I'd kind of like to explain a little bit. There was postings about a meeting being held at our clubhouse with Ms. Sheehan representing Cranberry Village. I got a lot of phone calls from residents in regards to that. They weren't quite sure who she was, what it was about, what was going on. That was the first really that we as a board knew about it. They were concerned that there was somebody representing Cranberry Village, the corporation. So we decided to kind of go straight to the source and reach out and find out what was going on. We asked if there was a meeting with Makepeace. We reached out. We wanted them to know that they were absolutely okay to go and speak with residents of Cranberry Village to have this, but that they needed to know that this person was not representing Cranberry Village, the corporation. She was, I guess, representing a group of residents, a small group of residents. I'm not really even sure how many. That being said, when this project had started months ago, and the trees started coming down and things in that area, we as a board at different times had discussed some of the concerns that we had. When they were doing work a couple of years ago, we went to, I believe it was the planning board where they issued the permit for one of their jobs that they did. We voiced our concerns, some of the things, truck traffic was a huge one. We have our two accesses for our residents exit one onto Federal, one onto Cranberry. It's a big concern for us. Our residents, mostly seniors, pulling out with the trucks. Not being able to see when the trucks come around from Cranberry up to Federal. So we addressed some of those issues at that meeting. The planning board they were great, Makepeace was great, they listened to it, and they actually added those things straight to their permit. They diverted some of the truck traffic closer going out to 28, not coming up through the community. They took care of some of the visual aspects that were a problem. And that was put into their permit, and that was pretty much the extent. When this started again, we had some concerns. We had discussed potentially reaching out, seeing what was going on, addressing some of our concerns. When this meeting was posted, that was pretty much when we reached out. We met with them for more informational, find things out. Our residents were concerned based on some of the things that they were hearing, that it was going to potentially poison our wells, it was going to ruin our water. So people were getting concerned. We as a board felt we needed to get all of the information that we could so that we could address our residents, which it's scheduled for our monthly board meeting this month on the agenda to address that with our residents, to let them know that we've met with them, had a conversation, brought up some of the issues that we, had, and that we were going to invite them to come and speak publicly at either another board meeting or depending at another time to kind of put some of that. So that's basically just why we reached out and why we were doing our due diligence. We didn't want the community to get the idea that they were being represented by somebody if it was, not actually factual. So that was pretty much how it all came about.
And at the end of the meeting, were you satisfied with the response you got from Makepeace?
Very. I mean, he said, we do have a good rapport. We try to have a good rapport with all of the companies, all of the businesses in Carver. We try to, reach out when we're looking for things to be done. And again, we do have a good rapport with Makepeace. I should probably, just for the record, because it's been brought up, people getting gifts or whatever. We have had some functions. We've had, craft fairs, and Makepeace has donated a couple of little craft baskets for us to raffle off. And I want to be, forthcoming with that. I mean, although I am going to ask for either an ATV or a, something bigger, where I hear that's what they give out now. So, but, just for full disclosure, that's what we've gotten, is a little bit of, gift baskets for our raffles. So.
And can you explain for me again, in your own words, how it was that there was confusion about who was representing or not representing the association?
So I don't have it with me tonight, and I don't know verbatim, but there was, Mary might be able to speak a little bit better. There was a posting, or actually the people I think that posted it are here. They can maybe address what it actually said. But it alluded to the fact that they were having a meeting on a Friday at 3:30 at the clubhouse in regards to what was going on, over at Makepeace, and that Meg Sheehan was representing Cranberry Village. It kind of alluded to that. Like I said, I don't know verbatim. Some of the residents read this. When you post things in the mail sheds, it becomes, it's like that telephone game, it spreads. And so they reached out to the board, as they should, with any concerns, questions. We didn't really know anything about it. So it was hard to answer their questions, but they were concerned. Some of the things that they had been hearing about was, that this could potentially ruin our wells. I don't know if you're aware, Cranberry Village just got the wells back from the town of Carver after all those years. And we're maintaining our own utility now and doing very well, I might say. So that becomes a concern because, doing this and handling the wells, people now hearing that water could be affected and bad, it's a concern. So we as a board wanted to gather as much information as we could and went straight to the source.
Very good. Young lady, do you have anything to add?
Nope.
Thank you both for coming today.
Thank you.
Is there anyone who saw the poster that can speak to that? Did you see the poster?
I wrote it.
Come sit. And identify yourself, please, for the record.
My name is Linda Jacobs. I'm a resident of Cranberry Village, and I live at 41 Piper's Way.
Okay.
I wrote the poster. It was an announcement. I wrote it after consulting with Ms. Sheehan as to the date. And I think the poster was, I put it up about 2 weeks before the date that we expected we might be able to meet with the Makepeace attorney.
I'm sorry, I don't mean to, was that the June 28th date?
Yes.
Okay.
So Ms. Sheehan had said, to go ahead, put it up, at least let people know, and we probably would be able to get that date. And if not, we would amend the poster. I didn't allude to anything, and I absolutely did not say that Ms. Sheehan was representing Cranberry Village. Never said that, because she's not. The poster, I don't remember what it said, but what I meant was that Ms. Sheehan was representing people who had concerns about what Makepeace was doing. And I know that they're in this appeal, the concerns, those of us who have spoken here consider Ms. Sheehan to be representing us. So it may have been my poor choice of words that I may not have said Ms. Sheehan is representing several people who live in Cranberry Village, but so people may have gotten the wrong idea. But I never said she was representing Cranberry Village.
Okay. Well, thank you for that explanation.
Pardon me?
I said
And the
thank
other
you for
thing
that
is,
explanation.
can I add something?
Yes.
My experience in the 3 years that I've lived in Cranberry Village is that our board president, Brenda McCall, exaggerates and does not tell the
No,
truth.
no, no, we're not going down that road.
Well, excuse
No,
me.
no,
I
no.
just want to say that...
We're not getting into
I'm not going to
personalities.
say anything else about her, but I'm not sure that there was an outpouring of concern about this, calling, because this has happened before. There may have been a couple of people who called concerned, wondering what this was about, but it's not like there was a huge disruption in the community. Because we have signs, I have a sign on my front lawn to stop the sand mining, and if people were that flipped out about what was going on there, they would have come to me and asked what's going on. So I'm not exactly certain that that account was accurate. That's all I'll say.
Okay. And thank you for that explanation.
Excuse me.
Not yet. Does anyone else from the public who has an interest in this case, would they like to be heard? Yes. Come right up. I recognize you from the last time. Could we have your name and address, please?
My name is Amy McCain, also known as Amy Merriam. I live in Cranberry Village, opposite where the new digging is going to start. My only comment, and this is not personal, is that there has been no communication between the board and the small group of us that are complaining. We rented the clubhouse by ourselves. We didn't have to go through. We all own the park, so we can do things in little groups without the board permission. They reached out to Makepeace, but they did not communicate to us anything that happened. We didn't even know they had a meeting. So Makepeace should be talking to us, not the board, because the board does not represent us. Meg Sheehan represents us.
Who is us?
The three or four of us that are doing this complaining.
Okay. Thank you for your
We're
comments.
trying to get more people by putting out the signs and the posters and things. We're trying to get more people in.
Okay. Thanks again.
Because we have concerns. Thank you.
Who else would like to be heard besides Ms. Sheehan, at least for now? Anybody else? I think, with all, in all honesty, this board probably heard most of the concerns that are in your minds, pro or con, at the last hearing. We took every single public comment from every single person who wanted to be heard. So if there's anything different now that anybody would like to weigh in on, I'm certainly willing to entertain that comment, and I know up here we're all ears. Nobody? Okay. So, oh, I'm sorry.
May I just add something that's totally not personal, but that I would like to add to what I find?
All right, come back up.
It's not personal. Our bylaws for the Cranberry Village Association clearly state that Board of Directors meetings are open. They are all to be open unless there's an issue, an executive session where confidential information has been discussed. While I was doing research to find out about our park's relationship with Makepeace, I went back into the minutes that are posted on our information page to find out. I had heard that there had been a meeting between our president, vice president, and Makepeace at some point, and so I reviewed all the minutes to find out when that was. And about 4 years ago, there was an announcement at one of the board meetings that there was going to be a meeting between the president, vice president, and Makepeace. So I asked at a board meeting if that had occurred and what was the outcome, and they said that that meeting had not occurred, that those two people had come before us, something in the town. So I reviewed all the minutes. I looked through all of them to find about this meeting, and there has been no discussion among the board at a legal board meeting, one that's open, about anything to do with Makepeace or the sand mining or anything. So the accounting, that this was discussed at a board meeting and the residents were aware is not accurate according to our official meeting minutes.
Thank you for that. Anybody else like to be heard? Mr. Crossan, since you began the evening, do you have any further comments at this time?
If I may, just
Quickly is good.
This will be very quick, I promise. I'd like to make 2 points. First of all, if you'd like to see the notice that was published, we do have a copy of it, although I only have it on an email, so I'd have to get it printed. Happy to read it to you if you'd like. The second point I just wanted to make is there are a lot of people standing in the hallway. None of them are comfortable speaking here. Not because of you, they're just not comfortable speaking. I've been doing this a long time. I'm not even comfortable speaking, but they aren't. But the reality is that every one of them understands that the consequences of Ms. Sheehan's pursuit has impact on their families. They're hardworking people who work in this community with wives and kids, husbands maybe, there are men and women here. And I just hope you are mindful of the fact that they are here tonight because it matters to them. That's really all I had, sir.
And I would say in response, Mr. Crossan, that all these other people who are not necessarily pro-Makepeace also have legitimate concerns.
No question, sir.
And that's why they are here tonight.
No question.
But thank you for seeing this as an even-handed situation. We hope even-handed.
Thank you all.
Okay. Ms. Sheehan, a final comment or two from you.
I'd just like to address the facts of what's going on here. I think there's been a lot of confusion about the expansion of the sand mining operation at 59 Federal Road and what the Zoning Board of Appeals appeal is about. This appeal is about the operation of the freight and truck terminal at 46 Federal Road, okay? Cranberry Village is next to 59 Federal Road, where Makepeace has undertaken a 120-acre sand mining operation. Okay, that has nothing to do with whether they have a zoning special permit for a truck terminal. These things are happening simultaneously, so I believe that there's been some overlap and confusion about people's concerns. What the chair of the Cranberry Village Association mentioned was a 2020 special permit application that AD Makepeace submitted to the Earth Removal Committee, not the Planning Board, for a permit to mine 4.4 million cubic yards of sand and gravel over 85 acres, and that sand and gravel is worth about $36 million. That is being done in phases under the alleged purview of the Earth Removal Committee. And in the spring of 2024, the Earth Removal Committee, claiming that this was just a 200-yard expansion, approved the expansion of that earth removal operation at 59 Federal Road, not 46 where the trucking terminal is, to expand even closer to Cranberry Village. That's another 20 acres of mining. The clear cutting started this past spring, as Mr. Mason, who's sitting here, knows, and that was what caused some of the concerns of the Cranberry Village residents who were hearing the noise, not able to open their windows. That has nothing to do with 46 Federal Road. My name being on a flyer had more to do with the general community concerns about the impacts on Cranberry Village residents from the expansion of that $36 million mining operation, being done under the rules of agriculture, I might add. That permit was granted during COVID, at the height of COVID, at a hearing that was held in the elementary school or middle school in person. And the only person that was notified was the president of Cranberry Village. The residents of Cranberry Village were not notified by the Earth Removal Committee. So it is only as this operation got closer and closer to their homes that they became aware of what was going on and where the sand was being hauled to, which of course is AD Makepeace, Reed Custom Soils, where it is weighed and transshipped out to various customers. As Jim Kane admits, the construction, concrete, and asphalt businesses that they service. So yes, there are a lot of people in the hallway, but there are also 200,000 people that rely on the sole source aquifer that is being strip mined and shipped through Reed, okay? We have world-renowned hydrologists who have talked about the impact of this strip mining across the 2 square mile area on Federal Road. 2 square miles of strip mining, all under earth removal permits from the Carver Earth Removal Committee for 50 trucks one way, going on for a dozen years now. That is a separate activity. It's an earth removal activity. Some of the stuff is being hauled directly to customers and some of it is being transshipped through Reed. We're talking about the transshipping. We're talking about trucks possibly coming in from other locations other than Makepeace's own operations to be transshipped from Reed. No one has any idea of what is going into Reed and what is coming out. And that is what this is about. It is not a manufacturing facility as originally presented to the planning board in 2014. What are they manufacturing? They are not manufacturing any kind of a product. There is no zoning permit to operate a freight terminal. So whatever the chair of the Cranberry Village Association was hearing about me or implying about me and who I represented and who I didn't represent, yes, there are 200,000 people across southeastern Massachusetts who are extremely concerned about the sand mining and the strip mining here in the town of Carver, being done under many different permits. You might have seen our Sand Wars report. You can go to the website sandwars.org and read the entirety, and you can hear about the 2,600 acres of land that has been strip mined for sand and gravel, enough trucks to circumnavigate the globe 1.3 times. And 75% of that is being done, or has been done, and is being done by AD Makepeace. And yes, there's a lot of concern because the Earth Removal Committee recently, in February of 2024, gave AD Makepeace a permit to expand the earth removal operations at 46 Federal Road. And yes, people in Cranberry Village are concerned about that too. But we are asking you to take action against an illegal transshipping operation. And I urge you to read the report and watch the video because there's a global crisis of the type of silica sand that is being mined in Carver, and it's time for people to wake up and pay attention to the exploitation that is happening because as the world-renowned experts, including the US EPA, have said, the sole source aquifer is vulnerable to contamination. When you strip away the trees, the vegetation, and the sand, you are stripping away the natural filtration for the wells. The Cranberry Village well, the zone of protection, is on the same land where Makepeace's Reed is located. So there is no, those are facts. And I urge you to look into the facts and find out exactly how many trucks are going in and out of Reed and what exactly they are doing there. Thank you.
Mr. Crossan, that poster you said you had on your emails,
I do.
can you supply that to the board for its record?
I can.
And can you get that to the planning department tomorrow?
Yes.
Since it was mentioned prominently here tonight,
By
I'd
email?
like to make that part of the record.
By email? Is that okay?
Yes,
Yes, I can
by
do
email, yes, and then turn around and get it to me.
that.
Thank you.
Thank you.
I have one thing that I need to read into the record, since we're still hopefully wrapping up shortly with the public comments section. This was an email that I received that I will also make part of the record. And it's very short, and I'm going to tone it down because it's emotional and heated, but it's from a Tim Westover, who lists an address on South Meadow Road in Carver. And he says, hello, I want to add my comments to the public comment portion of the upcoming Wednesday night meeting of the Carver ZBA. This was sent this past Sunday to the planning department, forwarded then in turn to me. This is for case number 131-2, 2-4, 4-3 for the 7/17/24 meeting, tonight's meeting. I want my comments to be read aloud during the meeting. I do not consent to the waiver of their being read aloud. Quoting now, "For the past 3 years, I have watched Attorney Sheehan and her groups waste an enormous amount of taxpayer time and money on claims that go nowhere. Her findings seem riddled with mistakes. Look at what she did with a suspended engineer at Planning Board with another project. She racked up failure after failure at the Planning Board, the Board of Appeals, the Conservation Commission, Conservation Committee, and multiple town meetings. Why do we have to keep wasting town money on this? This woman forces our town to spend huge sums of legal bills defending... No, wait a minute. Wait a minute. This woman has has forced our town to spend huge sums of money on legal bills. When will this stop? And that was the extent of the email. We've had many opinions offered tonight from a lot of different people, some of them hot, and I don't think that this is out of line at all to read, especially since this came into the record, and I'll now make it part of the record, as I have made all the other ones part of the record that we have received, including Ms. Dormer's. Now, it's very warm in here. I think that what we need to do is maybe take a 10-minute break, come back at about 8:45, we'll get the air conditioning humming again, and then we will move forward with this case. So this board now stands in adjournment until 8:45. Thanks, everybody. I think will be our decision announcement phase of this case. So, without any undue delay, let me jump into this. And I have some suggested findings for the board members to consider. But first, do I hear a motion to close the public hearing?
Motion to close the public hearing.
Do I hear a second?
Second.
All in favor?
Aye.
Okay, so this hearing is closed, and now we can go to some suggested findings that I would ask the board to consider and then vote on. And we're going to go through these individually so that we don't have a mass of findings and facts to consider all at once. Everybody good?
Yes. Good.
First, I suggest that the board find that the principles of collateral estoppel and issue preclusion apply to this case. As an earlier matter decided by this board at case decision number 131-2, appealed to the Plymouth County Superior Court at docket number 2183 CV 00929, motion to dismiss allowed by that judge on October 12, 2022. No appeal was taken from that dismissal. And that case involved the same parties. The property referenced was the same, that is to say 46 Federal Road, map 131, lot 2-4, and the allegations of illegal and unauthorized sand and gravel removal necessarily involving truck activity, and the request for relief were largely identical. No changed circumstances in the interim since the 2021 case decision were said to have occurred. That would be the first suggested finding that I'd ask for the board to consider. Anybody have any questions, comments, or amendments that they'd like to make to this?
No.
No.
Do I hear a motion to adopt this first finding?
So moved.
Do I hear a second?
Second.
All in favor?
Aye.
Proposed finding number 2 that I ask everybody to consider. The board finds that the same petitioner in this case also had filed a separate request for injunctive relief in the Superior Court Department for the same property, 46 Federal Road, map 131, lot 2-4, at docket number 2283 CV 00585, due to alleged illegal and/or unauthorized sand and gravel mine operations necessarily involving truck activity, which was denied by the Superior Court on December 9, 2022. Thereafter, on May 19, 2023, the court dismissed this case on a motion for summary judgment. A little bit more. In the instant case, meaning this case, the applicant claims that its request for enforcement is based primarily on these trucking activities. However, the board finds that these trucking activities are necessarily and directly related to the earth removal occurring at the same property that was the subject of the earlier adjudicated cases that I've just referenced. Do I hear a motion to adopt this finding, or does somebody want to make a comment or ask a question?
So moved.
Do I hear a second?
Second.
All in favor?
Aye.
Just want to say, by way of an aside, not only has this board heard hours about what's going on, hours of testimony about what's going on out there, but it's not just us. Based on what I've just told everybody, this case has now been reviewed not by one, not by two, but by at least three, count 'em, 3 Superior Court justices. Next proposed finding. The board finds that the petitioner admittedly had both the incentive and a full and fair opportunity to litigate its concerns at both the ZBA and Superior Court cases described a moment ago, including that of an alleged operation of a trucking terminal at the subject site, and no changed circumstances have occurred in the interim. Do I hear a motion to adopt that finding?
So moved.
Do I hear a second?
Second.
All in favor?
Aye.
Aye.
Next finding. The board finds that on February 23, 2024, the Earth Removal Committee for the town of Carver issued a detailed decision as to the same property regarding earth removal activities conducted thereon by A.D. Makepeace Cranberry Company, and set forth certain controls concerning this property, including provisions regarding trucking activities. Do I hear a motion to adopt that finding?
So moved.
Do I hear a second?
Second.
All in favor?
Aye.
Next suggested finding. Notwithstanding the principles of collateral estoppel and issue preclusion, the board finds that the trucking aspects of operations at the subject site are necessarily and directly related to sand and gravel removal. And accordingly, this board does not have subject matter jurisdiction over the instant case, as it is now being asked to enforce a general bylaw and permits issued thereunder or not issued thereunder by the Earth Removal Committee for the town of Carver, despite the attempt of the petitioner to characterize this case as one involving zoning enforcement. Do we hear a motion to adopt that?
So moved.
There is
Second.
second. All in favor?
Aye.
Next. The board also finds that under general bylaw, not zoning bylaws, but general bylaw 9.1.7E, the A.D. Makepeace Cranberry Company and Reed Custom Soils LLC must report activity updates quarterly on a form approved by the Earth Removal Committee. On this form, A.D. Makepeace Cranberry Company and Reed Custom Soils LLC is required to report to the Earth Removal Committee the number of truck trips and cubic yards of earth removed in connection with its trucking activities at the subject site. Your motion to adopt that finding?
Motion to adopt.
Here a second? All in favor?
Aye.
Next, the board takes notice that at exhibit number 7, which we will attach to this decision eventually, page 6, which is a memorandum of decision in order on defendant A.D. Makepeace's motion to dismiss. On that case that went up to the Superior Court that was appealed from our initial decision. That's docket number 2183 CV 00929, where the court dismissed that appeal with the petitioner in this case taking no appeal from that decision by the Superior Court. And now quoting from the judge and the judge's written decision, the ZBA correctly decided that it did not have subject matter jurisdiction over enforcement matters concerning the earth removal provisions of the general bylaws. Do I hear a motion to adopt that finding?
So moved.
Second?
Second.
All in favor?
Aye.
What was that, ma'am? What was that? I'm sorry. What was that? This is
Next finding.
paying attention. Oh, yeah.
The board finds that under General Bylaw 9.1.9C, and I'm quoting now, the enforcement officer for the provisions of this bylaw, and it's a general bylaw now, not a zoning one, regarding earth removal permitting shall be the ERC, short for Earth Removal Committee, or their designee of the town of Carver, and not the building commissioner, who is the zoning enforcement officer for the town of Carver. Do I hear a motion to adopt that finding?
So moved.
Second.
Second.
All in favor?
Aye.
Next. The board finds as well that the petitioner in this case caused to be filed a demand for cease and desist to Reed Custom Soils on April 12, 2023, roughly a year before this case. Apparently, there was either no response from the building commissioner to this letter, or if it was unsatisfactory. In any event, the law allows a petitioner in these situations to appeal if there is no response or an unsatisfactory response. There was no appeal taken from the building commissioner's refusal to enter an order for cease and desist in connection with that April 12, 2023 letter. Do I hear a motion to adopt that finding?
So moved.
May I hear a second?
Second.
All in favor?
Aye.
Next. The board finds that the interest of the petitioner as an aggrieved person, if you will, under the law, based on the evidence presented, is too vague and attenuated to support a claim of standing in this case. Moreover, and this is the same finding, the board finds that a mere statement of an associational or corporate purpose which expresses a general civic interest is not enough to confer standing under the law. Injuries to members of an organization must be special and different from any injury to the community generally. There is no standing where an alleged injury inures only to the detriment of the community at large and not to the petitioner specifically. Do I hear a motion to adopt this finding?
Motion to adopt.
Second?
Second?
All in favor?
Aye.
Next. The board finds that there was no map 131 lot 2 as referenced in the application of the petitioner in this case, during the relevant time period involved in this case. There was no Lot 2. Do I hear a motion to
So
adopt that
moved.
finding? Need a second?
Second?
All in favor?
Aye.
Next, the board finds as well that no evidence was presented during the public hearings relative to map 131, lot 4-3, also known as 62 Federal Road. Do I hear a motion to adopt that finding?
So moved.
Second.
All in favor?
Aye.
Aye.
Let's move on to the decision phase of this case. I suggest that the board consider the following language to be incorporated in the decision of this case. The board declines to award the relief requested by the petitioner, that is a cease and desist order against AD Makepeace Cranberry Company and/or Reed Custom Soils LLC, and/or an order to the building commissioner that he requests legal action through the selectmen to town council. Do I hear a motion to adopt that decision?
Motion to adopt.
Hear a second?
Second.
All in favor?
Aye.
Next. However, the board does recommend strongly that the planning board or its designated agent meet as soon as possible with a designated member of the ZBA to answer any questions based on the evidence taken at these hearings, and also to conduct a site inspection as soon as possible to verify compliance with previously approved plans and determine if any action needs to be taken that would require approval from the planning board as a modification to the special permit and site plan review, all in accordance with its written decision dated September 23, 2014.
So moved.
Hear a second? All in favor?
Aye.
A copy of this decision, ladies and gentlemen, for those watching at home, will be delivered forthwith to the office of the town planner and the planning board in conjunction with what I just read a moment ago, so that they are aware of the actions of this board tonight. I'm comfortable saying to everybody in this room and everybody who has an interest in this case what I've said before. This board is bound by the law, not by our personal opinions. And if we were not bound by the law, some people up here, I think, might have said different than what we decided tonight. But since we are a country of law, we must follow that law. Otherwise, we're in a situation which we don't really want to think about. Now, the petitioner in this case is well aware that it has a right to appeal. It has taken that right up on a number of occasions, and as I said earlier, our board decisions, now 2, have been reviewed by at least 3 Superior Court judges. I'm comfortable saying that I think everybody was heard, that we have done our best to be patient and to conduct an orderly hearing. I think that's happened. And I wish everyone well going forward. But this is our decision tonight. This case is now over at this level. Thank you, everybody. Not yet, because I'm not done yet.
Okay, just making sure.
We'll be done in 5 minutes. Okay. We have, according to our agenda, which Ms. Cullum will pull out, a section C referring to correspondence. All of that correspondence that I received pertinent to this case, as I mentioned on record, is now in the file, to the best of my knowledge. Does anyone else have any correspondence or issues that they would like to discuss? We need to talk also about when our next hearing is going to be, our next
Do we have
meeting.
About
any
what? I
cases?
missed.
For-
Our next meeting.
Do we have any cases?
Yeah, we have anything in the hopper here? Or?
Yeah. Didn't you get the email?
No.
Next Tuesday.
No. Nice try.
There's one in the queue. I don't know if it's going to happen, but as soon as I know, I'll let you guys know.
Is it a garage? I was hoping
I
it
don't
would
know
just
what
be
it
a
is.
garage,
He's like,
something
please.
simple.
Yeah.
I don't know what it is. What else do I say? I think that's it from a scheduling perspective. I will write this decision and probably be done with it by the time this weekend rolls around. I want to spend tomorrow morning, a good part of tomorrow morning, trying to put it together.
So I guess my question is, in terms of a next meeting, I mean, how timely is that case? I mean, should
Well, I
we
don't
wait
even-
until after Labor Day?
I don't even know if it's been filed yet.
Oh, okay.
Oh,
All I'm told was that there's something percolating and that I'll know when they know, meaning the planning department.
Okay. Because I've got a few things going in August that are going to keep me a little bit busy, but
Well, that's too bad. Ladies?
August is a little rough. I've got 2 trips that I'm taking in August.
Where are you going?
Myrtle Beach and Denver.
You know, where
I
are
think
you
we should
going?
wait till after Labor Day.
I should be home in August, I'm hoping. But I'll be in Florida in September, so.
Well, since your walking partner will not be with you, I'll tell my wife to come out.
You can certainly have her call at any time.
Okay. So I think we're at the end of our session for this evening.
So we're not going to pick a date for a next meeting
No,
then?
I don't think
Okay.
it's necessary because we don't
Okay.
have any business to conduct just yet.
All right.
So I'll circulate a date once I know there's something that we need to take up and you guys can get back to me as usual.
Okay.
Okay? So do I hear a motion to adjourn?
Motion to adjourn.
Second.
All in favor?
Aye.
Good night, Carver.